Present with counsel, Your Honor, we have the plea paperwork, that's gonna be a plea, we'll get it done real quick.
Thank you. 2024 CR 0089, Mrs. Raymond Jesse Bexar III.
Custody.
Night Max 737524. State versus Christine Gabriel Sustaita.
Custody.
That's been dismissed.
Okay.
It was dismissed yesterday.
Okay, let's see. 2023 CR 10474, State versus Refugio Delgado.
Custody.
2022 CR 7135, State versus Frank James Hughes. That's the jury trial. We're beginning at 10 this morning. And CM 116 126, State versus Joshua James Zamora.
Present. Counsel present, Your Honor.
Okay, thank you. Okay, do we have the file marked copy of the motion for continuance? And can I get the file on?
Then we have that client and.
Okay, we'll wait, we'll wait.
And you have to come over with the file. Let's see what you got in it. I'll send a copy.
Have you all conferred about anything?
Not really, Your Honor.
Okay, that's fine.
I know I did. Your attorney is
Your case is not getting ready yet, so you're free to go to what one is the case is ready. So now, just stay in contact with your. Good.
Jose Flores. Valerie Corrales. David Frazier.
Yes. And then we're gonna go over it probably on.
Is there anyone named who's not called to the court today?
My little thing was like this hanging off yesterday in front of the jury. And I wanted, my OCD wanted to get up and go slam it on there, but I said, hey, I should be okay. We're good.
Now, is this system now allowing you to hear better?
Hmm?
Is this system allowing you to hear
As
better?
long as when they come up here, they speak in these.
But remember, we used to have to whisper.
Well, I still put this is my backup. This is for when I put my headphones on. Okay, so when you see me put those on,
So when they approach, which one are you
they
listening?
need to speak in these. They need to speak in these. And this will catch up for me to hear too.
Yeah, she's doing it already.
This one is kind of like, it kind of has a little circular thing. So if they just speak within here. On the Phillips case.
We're just waiting on the motion, okay?
Yes, sir.
On the Phillips case that I'm just finishing.
Yeah.
It was pretty good. It was pretty good. So.
Okay, we're gonna go on Brennand, okay? James Brennand. We're gonna go on James Brennand.
Okay.
On the motion for continuance. Tell me when you're ready.
No, if he wants us to, I can.
Okay, I'm gonna call case 10.
Line, please.
2022 CR 11443, state this is James Brennand. Will the lawyers please make their announcements?
Jay Norton, go ahead. Jay Norton, Nico LaHood, Patrick Valentine for Mr. Brennand, and he is president of the government, sir.
Okay, I'll note that Mr. Brennand is present in the courtroom and for the state.
Daryl Harris from the state, Your Honor.
I'm Lauren Scott.
And Jason Goss's.
You have to come up closer so I can hear you on the mics.
Yeah, y'all can speak
Thank
up,
you.
please.
Come up closer, please. Thank you.
Okay, so we are scheduled today for a change of venue hearing. I have a motion, defendant's motion to continue hearing on motion to change venue that was filed yesterday at 5:35 p.m. Okay, defense, can you elaborate on that?
Judge, we filed this motion to change venue alleging both of the grounds provided in the Code of Criminal Procedure, and we're now seeking to continue it based on recently revealed information regarding the District Attorney's Office's relationship with a organization known as the Wren Collective. Recent reporting, and this is just in the last week that we all learned about this, that reveals that the District Attorney's Office was, it appears, taking direction on matters of messaging and possibly actions to be taken in a case, in multiple cases, including this case, from this Wren Collective. Now, how that relates to the motion for change of venue is that one of the grounds we've alleged is that that there's a ground in the Code of Criminal Procedure that there's a dangerous combination of influential persons which make trial in the county of prosecution unfair. Now, DA Gonzales came out right after the shooting and made statements that we have alleged and we believe were calculated to inflame the public and prejudice the defendant in any potential jury pool when he does go to trial on this case. Now it appears that the Wren Collective and one particular lady were delivering to the District Attorney's Office talking points. We know that from the public reporting and the text messages that have been released. Apparently consulting them on whether and when to dismiss the criminal charges pending against Eric Cantu, and directing other such matters related to the investigation and prosecution of this case. We don't know more, and that's why we filed a subpoena commanding the district attorney to deliver all communications limited to this case. We're not seeking everything with the Wren Collective, but that would be overbroad for the purposes of this hearing. But we are seeking any communications with the Wren Collective and its employees and agents concerning Mr. Brennand's case. We don't have that yet. We understand we just hit them with a subpoena yesterday. We wouldn't expect them to show up to court with all that information. And so we're seeking to continue this hearing to another date to give the district attorney time to compile the information they are commanded to produce.
And specifically, Your Honor, we were asking for all the communications with all members of the District Attorney's Office and the Wren Collective. So I think they will need a little time to research that as well.
Okay, and what does the state say with regards to the motion for continuance and the subpoenas that you were served with?
Given, as counsel framed it, notice of the subpoena when it came in, and he's right, we don't have responsiveness because they added additional names beyond what was noticed. If this makes sense, we don't object to their continuance while we try to honor it. However, we do intend to file a motion to quash parts, if not all of the subpoena to the court. Subsequently, we may ask for an in-camera inspection of what's turned over, because from the state's response, none of that is material to the motion for change of venue as described therein. So I guess the direct answer, Your Honor, is we don't object to the motion for continuance, and we seek the opportunity to respond while we also address the subpoena.
Okay, so you anticipate motions to quash the subpoenas that you were served with?
Yes, sir.
Okay. And the motion for continuance, no objection from the state, correct?
Yes, sir.
Now, for the defense, I'll note that you quoted section Texas Code of Criminal Procedure 3103A2, and you did quote the first part of that section, but the operative question is this dangerous combination that you believe may or may not exist. Even if it does exist, the question is whether by reason of that, your client cannot expect a fair trial. So that's the operative part that I'm looking at in that section. So I'm sure you'll get to that at the proper time. That'll allow you to continue the case then. So we're going to continue the case, and how much time are we talking about? For now.
When speaking to Mr. Gonzales yesterday, we know we sent requests to county IT looking for the expanded set of emails. I don't have an update as to when they can get that to us. I will make some inquiries, and I will try to relay that both to the court and council over the course of today, as soon as I can.
Okay. So do you want to reset it for 30 days then? Is that sufficient time for you to respond to the subpoena? If you do, you may not file motions to quash, you know. So is 30 days sufficient for both sides, or what are you requesting?
I anticipate 30 days would be fine, Your Honor.
Defense?
That sounds reasonable.
Okay. Now,
Oh, and I just would note, and this isn't something the court needs to decide today, but in addition to what Bexar County IT would be able to produce, we have requested information on private devices as well, because there are allusions in the text messages released so far that there were communications made to private accounts.
okay, well, I mean, at some point, give me some case law on that, and then we'll see where that goes. I don't know what the state's gonna do, but I know that they have been served with a lawful subpoena, and whether they comply with it outright or attempt to quash a subpoena, that's up to the state, and we'll cross that bridge when we get to it. But for now, this case is gonna be continued, to give you time to potentially get that information. And what date are we looking at?
March 7th for 30 days.
Okay, so, I'm gonna note here on the motion, March 7th, 2024, at 9 a.m. For both sides to present themselves here in court. If there are developments prior to that date, you can always come in and announce a status hearing so that we don't waste time.
Yes, sir.
Yes, sir.
Anything else from your side? State,
No, sir.
defense?
No, Judge.
Okay, you all excuse your client to excuse. Thank you all for.
Thank you, Judge.
Okay? Well, take care.
Counsel, defense?
You switch. Gentlemen, go switch, please.
Gentlemen, I did some research last night. It's kind of thin on that second one.
Well,
Just speak for thought, I mean, I get it.
yeah, I mean, hopefully we'll find something, but I think when you specifically request to use your private device, so you're not using your county device.
Yeah, that's an interesting issue, so, that issue. Okay. Y'all have a great day. Legal.
Yeah, well, I just wanted a date.
Understand.